I'm Corey Costello, and this is Tehachapod's Eye on the Capitol. Eye on the Capitol is an informative look at state and national legislation that impacts your life in Tehachapi. From new proposals, new laws, and even future ballot measures, we do the research and pass on that information to you while you go about your life. On today's episode, a major California Supreme Court decision protecting Tehachapi's Measure S and other local control functions benefiting all cities in California. Plus, the state legislature and the governor passed a budget just in the nick of time, and an update from expectations for the November 2024 statewide ballot. We start in San Francisco, where the California Supreme Court has sided with the state legislature on the future of the proposed Taxpayer Protection and Government Accountability Act that had received the required signatures to reach the November 2024 statewide ballot. However, the initiative, which sought to revise the California Constitution, was the subject of a lawsuit challenge brought on by the governor and the state legislature, who were seeking a pre-election review of the initiative due to its revision of the state constitution. The Supreme Court issued a writ on June 20th, siding with the legislature and ordering the California Secretary of State to not place the initiative on the ballot since it would illegally revise the state constitution. The measure, backed by some of California's wealthiest corporations, would have redefined what was considered a fee or a tax in the Constitution, an act that the legislature argued was not available via the initiative process. In their opinion, the Supreme Court ruled that while amendments to the state constitution are allowable via voter referendum, revisions of the Constitution are not and require either a two-thirds vote of the legislature to be placed on the ballot or a state constitutional convention. The measure would have challenged millions of impact fees, code enforcement penalties, and put at risk hundreds of approved voter referendums passed prior to the enacting of this initiative. Currently, local governments are allowed to study and charge impact fees to developers for the impacts their projects have on utilities and traffic. This initiative would have opened thousands of legal challenges to those fees and required an even broader nexus between the fees charged and the projects they would benefit. Locally, this initiative would have not only challenged fees in the city of Tehachapi, but put into question the November 2022 local voter approval of Measure S, the city's essential services and local control measure, since the sunset on that measure was, quote, until ended by voters and not a hard sunset date. While the city of Tehachapi was vocal in their opposition, as witnessed by the resolution to oppose the measure passed by the city council in 2023, supporters of the Business Roundtable initiative claimed in written correspondence to the city that Measure S, quote, should be safe since it did include some sort of a sunset clause. Should, however, is shaky legal ground that could have opened the measure, which was passed by nearly 60% of voters in the city, to costly legal challenges. In offering the rare pre-election review, the state addressed the Supreme Court in oral arguments as to why a pre-election review was necessary for this measure.
Under this court's precedents, the general rule is to delay review until after the election. However, that this court in Legislature versus Duke-Majan said that is based on the assumption that the delay will not require negative consequences. And in this instance, because of the retroactivity provision in the measure, delaying review will cause negative consequences and is already causing negative consequences. As a reminder, the retroactivity provision here reaches back over a 34-month period to January 1, 2022, and it puts at risk every tax measure that was passed in that period that doesn't fully comply with the measure, and every newly defined exempt charge. And as a consequence, governments right now, as we speak, up and down the state, they're in the budget season. They're trying to balance their budgets. And they have to do so without knowing what amount of revenue will be reasonably available to them, because if this measure passes, they may lose multiple sources of revenue. So that is already causing a great deal of harm. And as we move towards the election and after the election, the harm will only continue.
That was attorney Margaret R. Prinzing on behalf of the state during the oral arguments on May 8th. Other fees paid by developers, including water, sewer, and traffic mitigation, would either be challenged or forced to undergo expensive restudies of those rates to place a subjective actual cost of improvement on the fee structure. Actual cost is difficult to measure as the fees are adopted on 5-year cycles with an engineer's estimate of cost studied. Many of these fees are not spent towards a specific project until years down the road, which the cumulative impact of development projects force expansions of utilities such as wastewater treatment and water systems. This initiative would have effectively lowered fees, meaning rates for current customers would need to rise in the future to meet the demands of system expansions. Currently, new development pays their own way when impacting municipal systems and services. This initiative would have placed that burden on current residents. In addition, code enforcement, a major tool used in the city of Tehachapi to enhance public safety and remove blight, would have been hampered with new judicial process regulations, making it costly to find and enforce those with continued violations while subsidizing many of those legal costs from the city's general government funds. The California Supreme Court decision relied heavily on the 2009 case of Strauss versus Horton, summarized as follows, quote, "Under these constitutional provisions, an amendment to the California Constitution may be proposed to the electorate either by the required vote of the legislature or by an initiative petition signed by the requisite number of voters. A revision to the California Constitution may be proposed either by the required vote of the legislature or by a constitutional convention proposed by the legislature and approved by the voters. Either a proposed amendment or a proposed revision of the Constitution must be submitted to the voters and becomes effective if approved by a majority of votes cast therein at the election. Under these provisions, although the initiative power may be used to amend the California Constitution, it may not be used to revise the Constitution." End quote. The distinction between an amendment and a revision dates back to 1849. These provisions show that the amendment-revision distinction long predates the appearance of the initiative process in California. According to the justice's decision, the justices also cited case law that the very term Constitution implies an instrument of a permanent and abiding nature, and the provisions contained therein for its revision indicate the will of the people that the underlying principles upon which it rests, as well as the substantial entirety of the instrument, shall be of a like permanent and abiding nature. On the other hand, the significance of the term amendment applies such an addition or a change within the lines of the original instrument as will affect an improvement or better carry out the purpose for which it was framed. The decision invalidated the initiative as presented to voters because it would affect a revision to our basic plan of government in California by transforming the legislative power to levy taxes, the balance of power among the legislature, state executive agencies, and the electorate over the setting of fees, and the authority of local government agencies to set fees without legislative approval, or the possibility of referendum. The legislative power is also extended to other government entities, which, if the measure were allowed to continue, would delay many simple fees that currently ensure users of services, developers, and others pay for their impacts to facilities. Should the measure have passed, the Supreme Court pointed out that something as simple as a use fee for a recreation facility would have to be voted on by the voters prior to change. This would have cost far more than the service increase itself, in many cases forcing closures, staff cuts, and fewer services available to residents. The Tehachapi City Council joined a large alliance of cities in the state of California in an attempt to oppose the measure for its true impact, which was increased costs and fewer services for existing residents. The League of California Cities also noted the impact it would have had on voter-approved taxes retroactively, undoing the will of the voter. In addition, the measure targeted community-led efforts for ballot measures. For example, under state law, a citizen-led coalition can bring a taxing measure forward for a specific purpose or use once they gather the required number of signatures, and that measure would only need to pass via a simple majority from the voters. This measure would have undone the simple majority provision, and thus requiring 2/3 of the voters to approve a citizen-led tax measure, making it increasingly difficult for citizens to have priorities addressed by their jurisdictions. League of California Cities CEO Carolyn Coleman, who had been rallying cities to oppose the measure that would have put more costs on local residents, released this statement after the Supreme Court ruling. Quote, "No amount of funding from wealthy corporations will change the fact that the California Supreme Court decided the Taxpayer Deception Act is unconstitutional. It's great news for cities and their residents, and this dangerous initiative will not move forward this year, and local officials can now keep their focus on delivering vital local services." End quote. In other ballot news for the November general election, voters will not be deciding on a constitutional amendment to allow targeted support to improve the education and health of specific demographic groups, chipping away at Proposition 209, which voters approved in 1996 to ban racial preferences. The author, Assemblymember Corey Jackson, spoke with Cal Matters and says he is giving up trying to get the amendment on the ballot. Jackson, a Moreno Valley Democrat, said he's worried it wouldn't pass because of voters brought out by an anti-crime initiative, mostly in connection with the amending Proposition 47, which many believe has increased crime in California as the threshold for theft under $1,000 is considered a misdemeanor, which has resulted in organized retail theft. On the last episode of Eye on the Capitol, we explained that measure and the legislature's attempt to undermine the measure if it passes with additional legislation aimed at a softer approach that would invalidate the ballot measure if passed in November. Recent update on that showed there is some waning support from the legislature to pass those bills and authorize the governor to sign with the so-called poison pill provisions included. In addition, Governor Newsom announced Tuesday that 2 healthcare measures are coming off the ballot. He agreed to add pandemic prevention to an existing health institute. In return, the proponent is withdrawing a measure to tax income of more than $5 million a year to fund a pandemic prevention institute. According to Politico, support for the initiative dried up after the conviction of cryptocurrency entrepreneur Sam Bankman-Fried, a main backer of the measure. The governor also said he made a deal with the California Hospital Association to increase funding for the care of critically ill children. The proponents of the just qualified measure have agreed to withdraw it in exchange for the funding. On that note, the legislature and the governor have agreed to a $298 billion state budget just hours before the deadline that would have halted legislative payments. The agreement was announced between the governor, Senate Pro Tem Mike McGuire, and State Assembly Speaker Robert Rivas. The agreement assumes withdrawals from the Budget Stabilization Account, aka the Rainy Day Fund, over the next 2 fiscal years, using $5.1 billion in 2024-25 and $7.1 billion in 25-26, preserving budget resilience by maintaining $22 billion in total reserves at the end of the 24-25 fiscal year. The agreement does maintain the minimum required amounts under Proposition 98 for pre-K through 12 schools and community colleges, but $5.5 billion were paused and put off for future years under the plan. Other budget cuts announced were a reduction to state operations by approximately 7.95% beginning in 24-25 to nearly all department budgets. The reduction involves all categories, including personnel, operating costs, and contracting for savings of $2.1 billion to the general fund. A vacant position sweep, which means permanently reducing $1.5 billion and $762.5 million out of the general fund in 24-25 by reducing departments' budgets for vacant positions. California Department of Corrections Rehabilitation will see a reduction of $358 million above the statewide reductions for a total of $750 million in the budget window. No new prison closures were announced as part of the deal. The California Student Housing Revolving Loan Program will see a reduction of $500 million. Learning Aligned Employment Program, a reduction of $485 million one-time, which reflects the balance of unspent one-time Learning Aligned Employment Program resources. The Middle Class Scholarship Program, a reduction of $110 million, ongoing between 25-26. For housing, a reduction of $1.1 billion to various affordable housing programs. In healthcare, a reduction of $746.1 million for various healthcare workforce programs, which includes pausing the healthcare minimum wage increase signed by the governor last year. Reductions of state and local public health, which reverts $41.5 million one time in the current year, and ongoing savings of $8 million state public health and $15.9 million local public health, which aligns with all other state departments' 7.95% efficiency reductions. As far as revenue and internal borrowing, $13.6 billion. The agreement includes additional revenue sources and borrows internally from special funds. Significant solutions in this category include borrowing $6 billion from reserves. The agreement withdraws $12.2 billion from the Rainy Day Fund over the next 2 fiscal years, $5.1 billion in 24-25 and $7.1 billion in 25-26, and $900 million from the safety net reserves in 24-25, and another $6 billion in fund shifts. The agreement shifts certain expenditures from the general fund to other funds, including Proposition 2 supplemental payments, which applies prior CalPERS supplemental pension payment to the state's overall pension liability to reduce the required employer contributions in 24-25 by $1.7 billion and $1.3 from the general fund. Formula and Competitive Transit Intercity Rail Capital Program shifts $958 million general fund from current year and budget year to greenhouse gas reduction funds. Clean energy and other climate programs will see a shift of $3 billion from current year and budget year general fund to the greenhouse gas reduction fund. Just 2 years ago, the governor was boasting about a $100 million budget surplus, which he touted as unprecedented. Now the state is dealing with an anticipated $50 billion budget shortfall. So much so that the governor has announced a fiscal emergency for the state. Many of the cuts in the budget are expected to put Governor Newsom at odds with many of his staunch political allies. The Washington Post is reporting and quoted Lee H. Ohanian, an economics professor at UCLA, who claims that on several high-profile issues, especially housing and homelessness, Californians have seen little gain from a 60% increase in spending on the issues over the last 5 years. In April, for example, a statewide audit found that California has failed to track the effectiveness of some of its largest homelessness programs, meaning leaders have allocated $24 billion to tackle the crisis over the last 5 fiscal years and aren't sure how well it's working. The governor and the legislature are also expected to explore a policy change that would prevent the state from spending projected surpluses before the money lands in government coffers, as tax delays and uncertainty in the markets over the last several years impacted anticipated revenue that never came to fruition. That's the latest from Eye on the Capitol. If you have a question or would like more information about one of the topics covered or have an idea for a future episode, email us at media@TehachapiCityHall.com. Until next time, you keep living up, Tehachapi, and we'll keep an eye on the Capitol.